Good afternoon, everyone. Today is International Human Rights Day. That's December 10th, International Human Rights Day. So let's talk human rights because I'm a human rights lawyer. So I put up 3 reports as my backdrop. And one of the reports is collective impact. And it's an inquiry into racial profiling and discrimination of Black people by the Toronto Police Service. The second report is Broken Trust, that deals with Indigenous people and the Thunder Bay Police Service. And the third report, that's my backdrop, is Justice Tulloch's report, Independent Police Oversight Review. And these reports obviously indicates that there are problems, there are difficulties in terms of policing in Ontario and policing in an equitable manner. I mean, there are people who would want to deny the obvious, but we're not going to let them distract us. So human rights law in Ontario is provincial to the Human Rights Code, Ontario Human Rights Code, RSO 1990 CH 19, right? So we have the Human Rights Code in Ontario, and the Human Rights Code governs private and public relationships. We have the Canadian Charter of Rights and Freedoms that controls for government, and Section 15 is really the equality right provision in the Charter. Even though when we're dealing with racial profiling claims, we sometimes we buttress it as well with Section 8 and 9, depending on the circumstances. And we have the Federal Human Rights Code. And the Federal Human Rights Code deals with federal entities. So if you live in Ontario and you're discriminated against by a bank, for example, then the Canadian Human Rights Commission has jurisdiction. In Canada, in Ontario, shamefully, our human rights system has regressed. Our human rights system is broken. Our human rights system does not provide any modicum of accountability, transparency, intelligibility to people who are aggrieved, human rights applicants, nor respondents. And let me just pull up Tribunal Watch, and let me just share screen so you can see something here. I wasn't trying to pull Patricia Quick's screen up, so let's look over here. Let's bring it over here. So this is it. So we have three pillars in Ontario. We have the Human Rights Tribunal of Ontario and the Human Rights Tribunal of Ontario adjudicates human rights claims. We also have the Ontario Human Rights Commission. The Human Rights Commission deals with policy now. They intervene in some cases, and they also uh, so they deal with public education. And then we have the Human Rights Legal Support Center that provides legal advice to human rights complainants who fit within a certain fit within their criteria, and it's income wise, it's their strategic focus on cases, etc. But right now, the Human Rights Tribunal has 4 vacancies. It has a vacancy for a full-time vice chair. It has vacancies for part-time. It has vacancies for members, full-time and part-time. So these are the members who sit on the Human Rights Tribunal and determine your rights, our rights. And so these are the members. And there's their biographies. So, for example, Syed Dodd, he used to be a healthcare professional, a humanitarian relief and community service champion for 25 years. Right? And they say he's an advocate for diversity and inclusiveness, and that he received several medals, right? Some of them have law degrees, like Holly Gomes, Karen Dawson, Karen Mason. He doesn't have, Karen Mason doesn't have a law degree. Anthony Tamburo, classmate in law school. We both went to Osgoode Hall at the same time. Matthew Letourneau. And there's Robert Patchett, Edith Gatfield. He's one of the longest serving tribunal members. Rufina Bacchus. Robert Gabor. So these are the names. Amanda Connolly, she just resigned. And Marinus Lemers. Fiona Kate. He's one of the most qualified persons at the Human Rights Tribunal. But these are the names of the tribunal members. Emily Merton, Alyssa Chapnick. We went to Osgood Hall Law School together as well. She's a recent appointee. Emily Merton. She's a very experienced adjudicator. Sean Weir heads up the tribunal as its CEO. Right, he left a small firm to come there, but this is Tribunal Watch Ontario. And Tribunal Watch Ontario recently produced a report saying the Human Rights Tribunal of Ontario access to justice denied. And you see there, 93% of Human Rights Tribunal of Ontario decisions were dismissal of claims without a hearing. Most after being stalled for years and then ruled as abandoned by a tribunal that imposes onerous requirements on applicants. Even though a large amount of people filing claims have no legal representation, they're being compelled to file written, legal, and factual submissions on sometimes complex issues or else see their case dismissed. For example, the Human Rights Tribunal recently in Matthew Green's case dismissed his case on the basis that the Police Services Act as it then was, provided an effective remedy for Mr. Green in respect to his complaints about being racially profiled and harassed. Hopefully, Mr. Green applies for reconsideration and judicially reviews that. There are strong indications that people who may have legitimate claims are simply given up after their cases languished for years, mired in the HRTO process. Lawyers are given up too. I mean, how long can we as lawyers hold on to these cases? And they just sit there languishing. I mean, part of our job are advocates, but we have to get paid. You can't have 15 or 20 cases just sitting down in abeyance waiting for a dysfunctional tribunal to get its act together. And they're just sitting there and you're just backlogged with these cases, but you're not being paid because number one, there's no action taken on these files by the tribunal to move them forward. And so you can't get paid if you're not doing work. And then they say a system designed to accommodate applicants with no legal representation is increasingly using legal technicalities to deny hearings to those who want to present their case. And that's a problem for the very few applicants who get the full hearing on their cases. The wait between filing a claim and a decision is normally now between 4 to 10 years. I mean, in criminal matters, in the Ontario Court is 18 months. In the Superior Court is 30 months. The Human Rights Tribunal, which is meant to be fair efficient, just, and expeditious, 4 to 10 years to get your case heard. And then they say the HRTO drive to close files has led to a spike of dismissal of cases on the tribunal's own initiative without giving the applicants an opportunity to tell their stories so that they can be properly assessed on their merits. So the Human Rights Tribunal issued notice of intent to dismiss. And then they said the Human Rights Legal Support Center, an organization set up by the previous government to assist applicants in navigating the system, has been starved for funds for years and is shrinking. The Human Rights Code, with all its protections against discrimination based on race, disability, sex, and other personal characteristics, is one of Ontario's most important law. In most cases, the Human Rights Tribunal of Ontario is the only recourse for people to enforce their rights to be free from discrimination. Right? And so they go into detail now. And they say the tribunal watch has been sounding the alarm about the precipitous decline in access to justice at the Human Rights Tribunal and the Landlord and Tenant Board since 2022. And they've shown the light on the size of the backlog, the delays at every stage, the loss of in-person hearings, the expanded use of tribunal-initiated dismissals, and the alarming increase in abandoned applications when those applications have been stalled for years. Right? And then they show the backlog. And then they say 80% of applicants at the Human Rights Tribunal are not represented by counsel when they file their applications, which means that, the rules on pleadings and how to plead the applications, how to make the connection or link between the grounds and the reason for the adverse action may not be so apparent to a self-rep litigant, but most of these applicants can't afford to hire a lawyer. Even my clients, most of them, I essentially do their cases pro bono or on at a reduced rate because, quite frankly, they couldn't afford me. And this is what Tribunal Watch says. The HRTO is required by the Human Rights Code, Section 40 and 41, to adopt procedures and practices that offers the best opportunity for a, quote, fair, just, and expeditious resolution of the merits of the application, and to interpret its rules liberally to facilitate those aims. But the HRTO, in relying on formalities and technicalities, appear to be doing exactly the opposite, even though neither the court nor the tribunal own rules has changed. And then they say very few cases make it to a hearing to decide if discrimination has occurred. There was only 4 in-person hearings for 2023, 2024, and 1,342 electronic hearings. Parties can expect to wait for 4 to 10 years to get a hearing. The public is turned away from HRTO applications. New numbers are down. HRTO is now dismissing twice as many cases. Complainants are stuck in the backlog. And then they speak about the onerous filing requirements. Parties who fail to file a witness statement about their own evidence are now prevented from giving evidence. Supposed to file a Rule 16 and 17 sets out what happens when a hearing is to be held. You're supposed to file will stays. And I mean, if you're self-rep, you may not know how to navigate the rules. HRTO administrative errors result in unfair dismissals. The HRLSC is not able to support or fulfill its mandate to provide legal services to applicants. And then they do the conclusion. And, they say the legislation was reformed to give Ontario a reformed human rights system that for the first time allow people who believe they have experienced discrimination to have direct access to mediation and adjudication at a new human rights tribunal. The legislation enshrined an accessible dispute resolution system designed to facilitate participation by self-rep parties. It was assumed correctly that most applicants would be self-represented when they file their application, and the statute guaranteed the right to make oral submissions before an application within the tribunal's jurisdiction could be dismissed. So let me give you an example of when the Human Rights Tribunal functioned well. So this is a case that bears my name, Peters versus P Law Association. And it's a decision from the Court of Appeal on June 13th, 2013. And this is procedural history. So the situation at P Law Association launch happened in 2008. In 2009, this decision here, the tribunal consolidated the applications, as you could see. There were 2 complaints filed by myself and Brian Noble. And there's another decision here. Let's see what this one was. All right, so I asked for an adjournment. And then this here was the decision on the merits. So this is Peters versus P Law Association, 2010 HRTO 2411. So the incident happened in April of 2008. And by October 2010, there was a hearing. And this hearing took place over 3 days, involved 12 witnesses, including 10 who testified. 0 witnesses to the May 16th, 2008 incident between the applicant and personal respondents, right? So then they tell you background is the applicants are both lawyers. On May 16, 2008, they were all at the Brampton Courthouse for Youth Criminal Justice Act application arising out of a matter before this tribunal. That was KF versus Peel District School Board, and Peel Regional Police. The applicants were accompanied by Paul Waldron, a law student employed by Mr. Peters. All three, as evidenced by the photograph taken on the occasion, were dressed in business suits. Mr. Waldron is also black, and both Mr. Peters and Mr. Waldron have long dreadlock hair. Right? And the other lawyers that entered appearances in Mr. KF case were Saudation, two of them. One of them was white, and an employee from Peel Regional Police who accompanied her was white. But Peel Regional Peel Association focused on the black men, three black men sitting in the lawyer's lounge together on a May Day was unusual for them. They can be lawyers. They got to either be members of the public, they got to be paralegals. They can be lawyers. So they had librarian approached Peters, me, and Noble and Waldron to tell us that the library, this law association space, is not for paralegals. It's not for members of the public. You say you're a lawyer, show me your ID. Let me see your lawyer's ID. Show the lady the ID. The lady wanted the ID to come out of the wallet so she can inspect it closely. But that is what you call racial profiling. That is how you see some people in this society who are intelligent, but yet their actions are so arbitrary, so irrational, right? That you see black people and you already put them under suspicion because as far as you're concerned, they don't fit within your structure. They don't fit within the mindset of who should be here. And so you put them under suspicion. That is what Peel Law Association was really about. And that is what I've gone through for the 38 years that I've lived in Toronto. I've lived in Toronto since, well, I first came to Toronto in 1975 as a child. Then I went back to the Caribbean and then I came back in 1987. And to be honest with you, for Human Rights Day, I got to tell you that I've got to find ways to cope with the vicarious trauma. Even in places where they're not supposed to discriminate against people, you see anti-Black racism. You see you see irrational decision making. And you can't say anything about it. So if you say anything about it, they call you a troublemaker. And they penalize you. They take retaliatory action against you. They punish you. And why do you think that is? Because our systems are rife with systemic discrimination. And people, human actors within the systems, are infected with unconscious biases or implicit bias, they call it. The Court of Appeal in a case called Morris. See if we could pull Morris up. This is pulling Morris up. This is what the Court of Appeal said in Morris. Court of Appeal said it is beyond doubt that anti-Black racism, including overt and systemic anti-Black racism, has been and continue to be a reality in Canadian society, and in particular the Greater Toronto area. That reality is reflected in many social institutions, most notably the criminal justice system. Right? And when Justice Tulloch says the criminal justice system, it includes correctional services, jails, correctional institutions, custodial facilities. It is equally clear that anti-Black racism can have a profound and insidious impact on how those who must endure it on a daily basis. Right? It has an insidious impact on those who must endure it on a daily basis. It has an impact on me. I mean, look at me. I'm not dressed in a suit looking self-important as like a lawyer. I'm dressed in a hoodie. And then Justice Tulloch cited Lee and Terrio and so on. And he cited the Ontario Human Rights Commission report, a collective impact, interim report on the inquiry into racial profiling and racial discrimination of Black people by the Toronto Police Service. He cites the sort of treatment, one vision, one voice, change in the child welfare system for African Canadians. So he cites various cases, and then he says anti-Black racism must be acknowledged, confronted, mitigated, and ultimately erased. Right? That's what Justice Tulloch. That's what Justice Tulloch said. And Justice Tulloch wrote in Terrio as well, 2021 ONCA 517. And this is what he said in at paragraph 212. While often overlooked out of a tendency to distance ourselves from social ills plaguing our southern neighbors, Canada's long history of anti-Black racism has manifested in the contemporary phenomena of over-policing and disproportionate incidents of violence during interactions between Black people and the police. And he cites Lee as an example. Systemic and overt racism have long sustained unequal treatment before the law, leading to a crisis of confidence in the administration of justice in some communities. The current moment of reckoning with respect to systemic racism in Canada is long overdue, right? So we just dealt with Terrio and And so they're propositions. They're propositions that's relevant to racial profile. And there's no need to prove intent or motivation to racially profile. And that's true because sometimes racism could be unconscious. Racial profiling will usually be the product of subtle or unconscious bias, belief, and prejudices. Race need only be a factor in the adverse treatment for it to constitute racial profiling. Racial profiling is a systemic practice. Racial profiling is not limited to initial stops, and a person may experience racial profiling based on several overlapping and intersecting aspects of one identity. In a commission des droits de la personne et des droits de la jeunesse contre Bombardier Inc. at the Supreme Court. I appeared in this case as well. And let's go to paragraph 33 of Bombardier. Right, this is what this, so the Supreme Court used this definition of racial profiling. Right, this definition came from the Richards case. But let's go to PERT. There's a case called PERT. So we're gonna see if PERT was cited here. Easy to see that. You just go here. See, Peters was cited. PERT wasn't cited there, but PERT would have been cited in Peters. So let's see. No, PERT wasn't cited here either. Weird. Nasaya was a shopping while black case. But let's go to PERT. Because we want to talk about PERT. And PERT is 2006. That's PERT. We're going to pull PERT up. And this was a decision written by Justice Doherty. And let's see what he says in paragraph 91. So he's dealing with racial profiling here. He sets out Richards. So he sets that out. Paragraph 91, he says racial profiling is wrong, regardless of whether the police conduct that racial profile precipitates could be justified apart from resort to negative stereotypes on race. And he goes on. Speaks about, so that's PERT. And PERT has been used over, it's been cited 199 times. The Supreme Court in Lee cited PERT. And And if you look at if you look at Lee, right? The Supreme Court did a very good job here because when you look at the reports that they not only looked at the case law, but they looked at various reports from the Human Rights Commission, even the Race Relation and Policing Task Force from 1989. They looked at that report. They look at Tanovic. They look at Tulloch. They didn't look at Peters, but that's fine. But this is Lee. Very important decision about police conduct. Ditladine, well, Ali from Saskatchewan. Ali from the Saskatchewan Court of Appeal was an important case on racial profiling. And this case went to the Supreme Court of Canada. And the Crown didn't want the Supreme Court to decide this issue. So the Crown conceded this case based on the reasoning of the minority. So based on the dissent, they said, well, look, the dissent in Ali was right. And so this is the dissenting judge's decision in Ali. And the judge cited Grant. The judge cited Burt. The judge cited Brown. And Brown was an early decision of Justice Doherty. And he said racial profiling claims can rarely be proven by direct evidence. It's mostly circumstantial evidence. If racial profiling is to be proven, it must be done by inference drawn from circumstantial evidence, because certainly somebody isn't, very rarely would somebody say, well, I don't like you because you're Black. They always come up with pretexts. The attitude underlying racial profiling is one that may be consciously or unconsciously held. That is, the police officer need not be overtly racist. His or her conduct may be based on subconscious racial stereotyping. And the court there cited Brown, it cited Lee, it cited Bombardier. So the judge, the dissenting judge, really considered this issue and had a full grasp of it. Then there's Citladine is an important decision. That's from the Court of Appeal as well. Justice Feldman wrote it. And she cited all these reports from the commission. And so she essentially, Justice Feldman, essentially cited the same reports that the Supreme Court of Canada cited in Lee. Right? And then there's the Doddy decision. It's another Court of Appeal decision. And Justice Pacheco wrote this one. Let's see what Justice Pacheco said at paragraph 63. He said, put simply, passages such as paragraph 11 of Avery Brown and paragraph 33 in Bombardier are entirely consistent with the proposition accepted in Lee and Burt, where race or racial stereotypes are used to any degree in suspect selection or subject treatment, there will be no reasonable suspicion or reasonable grounds. The decision will amount to racial profiling. So that's quite an unequivocal statement, you know. There's no debate there. So I agree with Justice Pacheco. Right? Because he's right. Paragraph 93 of PERT says that a police officer engaged in racial profiling may be subjectively unaware. And then you got the Peters decision, which is my case. Right? 2013. You got Peters at paragraph 111. What does the court says here? Right? The court considered Raddick, Phipps, and so it says racial stereotyping will usually be the result of subtle unconscious belief, biases, and prejudices, right? See it there? That's a proposition in law. No direct evidence needed, right? In Bombardier, the court says that racism could take various forms. You know, and then you have Lee again. So this long live was to talk about Human Rights Day and to say that, look, if we have all these incidents and racism is the second largest ground of complaints before the Human Rights Tribunal, right? You have different forms of racism now and discrimination. You have anti-Semitic bias that has increased since October 2023. You have bias and discrimination against Arab Muslims that have increased since October of 2023. You have anti-Black racism, which has never gone down. Anti-Black racism has always been really, really high. And some of the discrimination are intersectional. So somebody can be discriminated based on their various identities. Right? So you always have to control for all of that. I wrote a paper that you can read, Peter's 10 years on. I wrote that last year. And this is a good paper to read. Right? All right. So happy Human Rights Day. Keep the fight up to ensure our dignity is our dignity, our values are protected. Because we live in a society we live in a society that continue to devalue us, right? A society that continue to treat us as though we are not important. And so we have to continue to fight and to fight with all our might to ensure that effects that that effects are brought to bear in terms of the International Convention on the Elimination of All Forms of Discrimination, in terms of the Human Rights Code in Ontario, in terms of the Canadian Human Rights Code, and all the other conventions that govern the human rights of human beings. I had a recent incident, and that recent incident illustrates how unconscious bias works, how people make arbitrary and irrational decisions. And you just have to shake your head. I could have took it on. I could have engaged in a fight. But for now, I let it go because I got to take care of me. Self-care is what is important. And that's what I posted on my Facebook page today. I made a post. I made a post about self-care because as they say, when you try to fly on an airplane, they usually tell you that in the event of an emergency, put your mask on before you attend to anyone else. And the reason why they tell you that is because if you're out of commission, you can't help anyone. So if you try to help someone, you don't put your mask on, you can lose consciousness, and then you're of no help to anyone. So let's see. So this is what I posted on my Facebook page today. I said we need to be in tune with our mind body and soul. Trust your feelings. And hashtag it self-care, lawyer, trauma-informed, Human Rights Day, dignity, self-worth. I mean, in life, people will hurt you. They'll desert you, but never, ever. I always tell myself that they will take your soul if you let them. Oh, don't you ever let them. That's the song. You just call out my name, and you know wherever I am, I'll come running. Right? So you always have to understand how cold people could be. And the truth about it is, I understand that very well. I understand that. And that's why I'm alert. And that's why I'm alive to the nonsense that people do at all levels. People just think they can use you. People just think, and they think you're not clued in because you're a human rights activist, because you're kind. They just think that they can abuse that. I see that all the time. It's like in the face of racism, right? Black people are dying. Black people are dying because of racism. And I would never defend that. Y'all could take that to the bank and bank it. I would never defend any status quo where black people are dying because of racism. I mean, I agree that jails aren't nice places, but people go to jail, whether they're on remand or whether they're serving a sentence. They didn't go there to be abused. They didn't go there to be assaulted. They didn't go there to be neglected. They didn't go there to be ordered. None of that. And so for Human Rights Day, we've got to call it as it is, and we've got to tell them, don't play with me. Don't play with me. Anyway, goodbye.